Hello, this is Robert Shapiro with Thomson Coburn's International Trade Group, here to talk about terms of sale, routed export transactions, and export controls. Thanks for joining us. I hope this is informative and useful to everyone. I'm the chair of the International Trade Group here at Thomson Coburn. My prior life, I'd like to say I was a customs house broker and freight forwarder before deciding to do something legal. Although that's not always well received with my freight forwarder friends and customs broker friends. Anyway, this is a topic that's near and dear to my heart because it marries the compliance aspects of what I do with the logistics aspects of what a freight forwarder and broker would do. So it's a nice melding of the two. It also covers ideas that are important in contract as well as in the compliance environment. So it covers a wide range of issues, and it becomes something I think that's interesting, and I hope that you will find it to be so as well. This is just a diagram kind of to give everyone a framework of what we are looking at here. This is an international transaction, a typical international transaction going from, we're going to talk primarily from U.S. to on export to a foreign country, and this is a diagram showing an ocean shipment just because a lot of the trade will be across oceans. And you can see going from left to right, the factory to the pier to a vessel across to another pier, to clearing customs, and then to a facility. And we're dealing with all aspects of this logistics chain when we're looking at Incoterms. This is a more complicated chain than a domestic transaction for a couple of reasons. One, we have a customs formalities on the export and customs formalities on the import. We have a greater distance for the transaction usually. We have problems with language. So an international transaction has additional complexities. The Incoterms, the terms of sale, Incoterm Rules, give a shortcut to defining some of these complexities in a way that everyone will understand. So some standard definitions. They provide some certainty and clarity to the transaction. Everyone should know the same set of rules that they're operating under. They help deal with the geographical differences because it standardizes the language. They help allocate risks according to the risk profiles of the seller and the purchaser of the goods. We deal with the roles of agents using the Incoterms, which is common in any international transaction, the role of a customs broker, freight forwarder, or other agents. And then the documentation needs. The Incoterm rules are inherently contractual terms, and we'll touch on why I emphasize that as opposed to a regulatory concept in a few minutes. But that's the distinction I'll draw. But they're negotiated, so you'll have greater control but increased responsibility, and so those are two of the differences that are going to be negotiated on how the Incoterms are used. Greater transparency or trust in the operation of your trading partner. Increased costs or lower costs and potentially increased profits. Uncertainty versus increased services. So once you rely on someone else, one, you do the services yourself. Compliance versus indemnification. Is one company going to take on the compliance risk, or is the other one going to? And are there going to be indemnifications based on how those risks are allocated? Risk of loss, and according to who has the best position to ensure those losses. The bottom two items here, which I've grayed out, by the way, the presentation that was sent yesterday was incorrect, didn't have these grayed out. And there was a new presentation sent this morning, so please refer to the updated one. Anyway, the bottom two items, revenue recognition and transfer of title, are grayed out because Incoterms inherently do not define these. They do not define where revenue is recognized or where title is transferred. They give an indication of where these may occur, but they don't define these. And that's a common mistake that people have when using Incoterm rules, thinking that they actually define title, transfer, or revenue recognition. I want to make sure that's clear. So this chart, and we're going to refer to it several times during the webinar, shows the various Incoterms. and they're grouped. There's the E-terms, which there's only one, Exworks or EXW, which you can see is where the seller takes on the least responsibility, and most of the obligations of the transactions are incurred by the buyer. And at the other end of the spectrum, at the bottom of the chart, we have DDP, or delivered duty paid, where the seller takes on most of the obligations and the buyer has taken on very few of the obligations. So the seller is delivering the goods all the way to the buyer's place of business usually, and clearing customs remotely. I've highlighted in red, or boxed in red, the E-term and the DDP term because I want to draw a caution here. The E-term is often very popular on export transactions for a bunch of reasons. Companies believe that they can absolve themselves of many of the compliance obligations by selling at Exworks, and this would appear to present that as we talk further. We'll see that that's not necessarily true. It also it would give some indication of an earlier recognition of revenue, and that may be true or may not be true, but one should balance the costs. The reason the E-term and the Exworks terms and the DDP term are highlighted in red is because these are the terms that create the most potential difficulties. And for the E-term, for Exworks, you have a buyer taking on obligations in a country, potentially taking on obligations in a country far removed from their home country. So the buyer is going to do export clearance responsibilities. So the buyer is going to take on those responsibilities in the seller's country. The buyer is going to have to work through agents in the seller's country to arrange for the transportation and for the movement of the goods. So there's an inherent increased risk for the buyer under an E-term. Conversely, there's an increased risk for the seller under the DDP term, the delivered duty paid term, because in that situation, the seller is taking on the compliance risks in a foreign country far away from their home, and they may actually not be qualified to be an importer of record depending on the law of that country. I tend to caution clients against these extreme, what I would call the more extreme level of the terms, and look more in the center of the chart for terms of sale that would be useful. I'll point out just in passing that the terms that are boxed in blue, FAS, FOB, CFR, and CIF, just to point out that those are inherently terms that deal with ocean transportation only. The common misuse of CIF and FOB for non-ocean transportation, that is a common error, and it derives from the use of those terms in the UCC and other places where most of the time they've been actually abstracted from the UCC now. The other terms are multimodal, so it would work regardless of the mode of transportation. So one of the things, what we're going to focus on is the idea that the Incoterms define who has export compliance responsibilities, as well as who controls the transportation of the goods outside the United States. As I mentioned earlier, the EXW, or Exworks term, is popular because it appears to place the export compliance responsibilities on the buyer of the goods, and therefore the seller of the goods, a U.S. person, can be absolved of having to do those, take on those responsibilities. And as we'll see as we go further, that's not the case. And I symbolize that here by the get-out-of-jail-free card. The Incoterms do not do that. I should also mention the Incoterms are contractual terms, as I said, not regulatory terms. So they, the U.S. government does not look at the Incoterms as being definitive of how the transaction is progressing. And I'll touch on that again as we go on. So back to our Incoterms chart. We're going to be focusing on export compliance issues. And as you can see here in the center of the chart, we have export clearance and forwarding fees, and I've highlighted those areas. Forwarding fees is indicative of who has contracted with the freight forwarder. So I highlight that because the freight forwarder tends to do the reporting on the export. So we have certain terms where the freight forwarder is contracted with or may be contracted with by the buyer. So the buyer contracts the freight forwarder, but the seller has responsibility for the export reporting. Those are the F terms right there. And so that creates a risk because the seller is going to be doing export reporting through a freight forwarder that they may not have privity of contract or control over. One of the things to watch out for. I will note that the F terms allow, as I said, the Incoterms are suggestive. The F terms allow the seller to select and contract with the freight forwarder at the option of the parties. We've already talked about the E term, and here the E term, the export clearance responsibility seems to be on the buyer and the forwarding fees, so the buyer is contracted with the freight forwarder for that. That would seem to be clear except for how the U.S. law works. So the U.S. law throws a bit of a monkey wrench into this nice, clean Incoterms chart. The U.S. law says all provisions of the Export Administration Regulations, the EAR, apply to all of the parties to the transaction. I have here all the parties to a routed export transaction, and I'll define that term as we go on. But the main point here is that the seller of goods in the United States retains responsibility and export control obligations in nearly all circumstances. They can limit them, but they retain some responsibility if you are entering into this international transaction. So while the E term would appear to say the buyer has taken on all those responsibilities, under U.S. law that's not the case. U.S. law inserts the idea, instead of buyer and seller, of principal parties and interests. Those are the parties that receive the primary benefit, financial generally, of the transaction. These are generally the seller and the buyer. We refer to them as the U.S. principal party and interest, which is generally the seller, and the foreign principal party and interest, that's generally the buyer. Not always that clear, but the U.S. principal party and interest retains many of the export control obligations regardless of the terms of sale. So the U.S. exporter has compliance responsibilities with regard to end-user screening. You have to know who your customer is, what business they're in, do they have the appropriate use for these goods, would these goods be transshipped or routed someplace else. The U.S. principal party and interest, the seller of the goods, has a responsibility to understand who that foreign person is. And use screening for certain goods, whether the goods are being put to a use that is impermissible under U.S. law, whether the goods could be sent to an embargoed country or be transshipped to an embargoed country. Is there any indication of that? The standard of knowledge for the U.S. exporter is whether there is any reason to know that these goods may be transshipped or sent to a wrong use. That's a pretty broad standard, and it is reviewed in hindsight. So oftentimes the information that is reviewed in hindsight is much clearer than it was at the time. An Arabic notation on an invoice for goods going to Germany may be suggestive of goods going to another destination, or Farsi notation may be suggestive of the goods going to Iran, and may not have been noticed at the time but would be noticed when the goods showed up in Iran. The U.S. exporter has the responsibility for ensuring that the licenses are in place and for classifying the goods. And as we see, these responsibilities carry on even if the U.S. party specifically contracts for the buyer to take on many of these responsibilities. The U.S. principal party in interest, the seller, retains compliance risk for all Incoterm rules. So the USPPI, it has different definitions under the two sets of regulations. It's worth taking a step now to segment this. There are two sets of reporting regulations that we're going to be dealing with in this webinar. One are the reporting regulations from the Department of Census in they're called the Foreign Trade Regulations. And that is every export has to have filed an electronic export information with the Department of Census unless it fits within one of the exceptions. The other set of rules are the Export Administration Regulations. the EAR, and they are maintained by the Bureau of Industry and Security. The EAR governs the regulations on what goods may be exported and what conditions are placed on those exports. So we have the foreign trade regulations, which deal with the reporting requirements, how we gather information, how the United States gathers information, and we have the export administration regulations that deal with how the United States regulates the exportation of goods. And they have some differences, and some important differences that make this topic particularly confusing. So let's start with the definition of the U.S. principal party in interest. Under the census regulations, that is the person in the United States who receives the primary benefit from the export transactions, usually the seller, the manufacturer, or an order party. It can be a foreign entity that's located in the United States at the time that they purchase the goods. The EAR, the regulating regulations, the export regulations that govern whether things can be properly shipped, define the USPPI slightly differently. The USPPI is the exporter, except in certain routed export transactions. There's that term again that we will be discussing very shortly. So what's it mean to be the exporter? The exporter has to determine the licensing authority and obtain a license or other authorization, if necessary, for any goods that are being exported. So the USPPI, the U.S. principal party in interest, except in certain routed export transactions, has to determine the licensing authority and get the license. You can't do that without classifying the goods, and that responsibility also lies on the USPPI. Also, the USPPI has to determine and control the sending of items out of the United States. When we get back to the Incoterms chart, which we'll look at, we look at who that freight forwarder is and who contracts with that freight forwarder, and that helps inform, doesn't bind, but it helps inform who may have the ability to determine and control the sending of items out of the United States. If the buyer is contracting with the freight forwarder, the USPPI, the seller, probably does not have that much control on the sending of items out of the United States, and we need to be cautious of that. So let's look at this Incoterms chart again. We see, at the Exworks, we see the USPPI, or the exporter, does not have the ability to determine licensing authority or obtain any license. Those responsibilities have been shifted off to the buyer contractually, perhaps, but maybe not in terms of the regulations, and would not have the ability to control the sending of items out of the United States. Again, those responsibilities have been transferred to the buyer. Under the F terms, FCA, FAS, and FOB, we have a similar situation. Again, potentially, because these can be changed by negotiation, where the buyer is contracting with the freight forwarder and arranging for the transportation. The seller may not be in a position then to control the sending of items out of the United States as they need to do as an exporter. May not be of serious consequence in many situations, especially if they aren't controlled, but it increases the risks of the transaction. One other element to put in here, until very recently, electronic export information was processed by the Department of Census in a system called AES, the Automated Export System. This information has now been ported over to CBP's Automated Commercial Environment. Fairly transparent to the end user. You still use the same systems to file your export information. It's just processed differently by the government. But there are important distinctions to remember. The Automated Commercial Environment is a more coherent system than AES was. It has improved targeting capabilities, perhaps improved reporting capabilities, and it does provide the government with a better enforcement tool. So we are dealing with a change in the environment where now the government has information based on export filings to be able to better determine whether things are potentially risky in a compliance sense to the United States. So now we're going to start dealing with what this means to be a routed export transaction and how it combines with Incoterms. So a routed export transaction, again, we have to deal with two sets of definitions. One is under the Foreign Trade Regulations, the information gathering regulations of the Department of Census, and one is under the Export Administration Regulations, or the enforcement regulations, if you will, the export control regulations of the Bureau of Industry and Security. So the Department of Census defines a routed export transaction as a transaction where the foreign principal party in interest authorizes a U.S. agent, think of it as a freight forwarder, to facilitate the export of the items from the United States and to prepare and file the electronic export information. There must be an authorization for both, to prepare and file the electronic export information and to facilitate the exportation of the goods. That's the reporting side of the house. On the export control side of the house, we have a different definition. A routed export transaction is a transaction where a foreign principal party in interest, the FPPI, authorizes the U.S. forwarding agent to facilitate the export of the items from the United States. There's no reference to the reporting requirements. It is merely because a U.S. forwarding agent is doing the facilitation of the export. Let's see what the implications of that are. Well, the first thing is that this created a whole bunch of confusion for people. There's some misunderstanding under the current language to require a USPPI to allow the foreign principal party in interest to assume licensing responsibility in all routed export transactions, because we have a foreign principal party in interest taking on the control of the exportation of the goods. Did that mean they also have the licensing authority? And they take on all those responsibilities. If we go back to our Exworks chart, we have allocated those responsibilities contractually to the buyer of the goods. The regulations say the seller of the goods retains that responsibility, and the confusion exists as to whether that contract was enough to change that. And the law says no. So specifically that the seller retains the licensing responsibility unless they specifically authorize and come to an agreement with the buyer that the buyer will take on those responsibilities. In an attempt to clarify this situation, the Department of Commerce, Bureau of Industry and Security has proposed new rules and a new term, the foreign principal party controlled export transaction. And that's a transaction meeting the requirements of a routed export transaction under the old rules, essentially, where the foreign principal party in interest, the buyer, assumes the responsibility for licensing through its U.S. agent and is responsible for the movement of the goods. So we have now, they've tied in two elements of the routed export transaction, if you will. A new term, the foreign principal party controlled export transaction as opposed to the routed export transaction. And the buyer then is specifically taking on the licensing responsibility and the movement responsibility. The only way to remove that the responsibility formally to the buyer from the seller is by agreement, and it has to be in a formal communication. Again, this is a notice of proposed rulemaking, but it clarifies some of the language that is in existence, and one could argue that it even puts in place what would be the best practices of people currently operating under these rules. So the notice of proposed rulemaking requires this formal communication. So the licensing responsibility must be delegated to the buyer by the seller in writing. The buyer specifically accepts the licensing responsibility in writing. The buyer provides a power of attorney to an agent and provides the seller with a copy of that power of attorney. That agent would be doing the licensing and arranging for the exportation, generally the freight forwarder. The seller provides the classification or necessary information to the buyer. That's important. If you notice what I said earlier, that the seller of the goods almost always retains some classification responsibility, and this proposed rulemaking clarifies that and makes it explicit that the USPPI provides the classification, the ECCN, which is the Export Control Classification Number, or relevant information to the buyer so that the buyer can classify. But the seller retains that responsibility. The seller is to provide any information that the seller may know may affect any licensing determination. That's important. And then the buyer authorizes the seller to receive certain shipment information from the agent. That's important also. Right now, I would strongly urge all exporters to make sure that they have in place processes and procedures to assure that they get shipping information from the freight forwarder on all exports, whether they're routed exports or direct exports. Exworks. The USPPI does not control the transportation or the classification of the merchandise. There's some benefits there and there's some costs. The revenue recognition may be a perceived benefit, may not be an actual benefit, but it may be a perceived benefit. It's only one of the factors, however. The terms of sale are only one of the factors in determining whether revenue is recognized early or late. There are no ancillary operations. As we talked about previously, that's not necessarily true, that the seller of the goods under an Exworks term of sale still retains responsibility for some compliance issues. And so the compliance issues, not my problem, is completely false. That's retained by the regulations. Unlike the contractual terms, the regulations reverse that and push responsibility back to the U.S. person in all circumstances, or almost all circumstances. It's more simple, not necessarily. Again, there needs to be specific agreements between the parties on who's doing export filing. So an Exworks transaction requires a little more paperwork than it would appear to be at first glance. And there's many uncontrolled risks. One of the things to balance in the Exworks transaction. But it's up to the buyer to obtain at its own expense and license an official authorization, any license or official authorization. That would be the contractual terms that would need to be clarified specifically in writing to meet the export regulation obligations under the current rules or the proposed rule. And these are there's notes at the bottom here of the terms under the EAR where the USPPI, as the exporter, is responsible for the licensing and the controlling of the sending of items out of the United States, and under EXW, as I've shown before, that is a hard obligation for the seller to meet. This is from the ICC, the International Chamber of Commerce, who publishes the Incoterms, and they say that Exworks is suitable for domestic trade, while FCA is usually more appropriate for international trade. And that's because you cannot reasonably, in most situations, offload that much responsibility to the buyer in an international transaction. It usually takes a step further, and FCA allocates those risks more appropriately for an international transaction. So let's say we have a controlled item. What's the idea of Exworks on a controlled item? And I've seen this in my practice where someone has something, it's controlled, the exporter, the USPPI, obtains the license because a foreign person can't get a license. They could have an agent, a U.S. agent, apply for a license for them. But I've seen it where the seller gets the license, hands the goods over on an Exworks basis to the buyer, and lets the buyer ship the goods. And this is just a piece from Clint Eastwood in Dirty Harry.
You've got to ask yourself one question: do I feel lucky? Well, do you, punk?
Handing someone a license where the seller has taken on the responsibility, is declared themselves to be the exporter, declared themselves to be the licensee, and handing that license over to someone else to ship the goods and not having any control on the exportation of those goods or where they're going is one of those things that I would consider to be fairly high risk for anyone in international transactions. The F terms are much more favorable. In all cases, the goods are handed over to the carrier in some way. So the seller of the goods has some idea of where the goods are going. There has to be a shipping document for the carrier to receive the goods, and so there's more transparency to the seller to be able to see where the goods are going. And as mentioned previously, under the F terms, the seller can also arrange for the transaction with the freight forwarder, use their own freight forwarder. That's negotiable between the parties. So under the F terms, you have a lot more control as a seller of goods. You get to see what the transaction looks like. You have much more greater rights to the delivery receipt or the bill of lading. It facilitates the compliance and puts more control within the seller's hands. So it approximates Exworks. You can have an FCA term where you deliver the goods at the factory, loaded on the vessel. That's the additional, on the carrier's truck or conveyance. That's an additional responsibility. But you can recognize it to the degree that the delivery of the goods at the factory would allow for earlier recognition of revenue. You can approximate that EXW term by doing an FCA at the seller's place. There's better control over export reporting. As I said, you still need information from the buyer's agents, but you're in a better position to get that. You still don't have the ability to use freight as a profit center, which under a CIF term or a CFR term, where the seller is charging the freight back to the buyer, there's often a chance to make additional profit on the freight, but it's more simple because you are not arranging the transportation, not responsible for the transportation. There's still uncontrolled risks, but they're fewer. So the F term would be one that we would favor for the reasons that we've talked about before, but it gives, first off, the USPPI or the exporter is responsible under the Exworks terms for the licensing and the determination of the licensing. It also is in a better position to control the sending of items out of the United States. So it presents a much more favorable compliance environment than does EXW. Let's look at some of the export compliance issues. So we want to control risks, and how are we going to go about controlling these risks? We have to be deliberate. You have to adhere to the chosen Incoterm rules. One of the things that I've seen in practice many times is the Incoterms are declared on the documents to be one thing, but by practice, the companies operate much differently. That creates a big problem. How do you, what then do the Incoterms rules that you're using actually mean? Do they mean what they say in the International Chamber of Commerce rules as they were written, or do they mean what the practices are? Creates a tremendous amount of confusion. So we suggest that one, be faithful to the terms used and be careful and deliberate in selecting which Incoterms are going to be used. Should establish documented procedures. Well, that's a common theme, I think, for all international trade compliance issues. But a written express assumption of licensing responsibility from the foreign principal party in interest if that responsibility is going to be shifted. The Notice of Proposed Rulemakings makes that actually clear, but it would be a best practice anyway that it's clearly stated that the buyer is taking on all licensing responsibility, and the buyer hereby agrees that they will be taking on that licensing responsibility. That the authorizations for filing the electronic export information are also clearly issued. This is a moment to think about that. There's a lot of authorizations that are issued in international transactions. Authorizations to customs brokers to clear goods, authorizations to freight forwarders to file electronic export information are but two. I would say in both situations that the companies should look carefully at how those authorizations are issued and to limit them. Unlimited powers of attorney or other authorizations are just recipes for additional problems later on. I like to encourage a limited time period in a power of attorney or authorization. It keeps the communication flowing between the agent and the exporter or importer. There's a reason for the agent to check back in with the exporter or importer, make sure things are right, and there's a reason for the exporter or importer to check on the operations of the agent. So I strongly recommend that any authorizations be limited in time, if not to the transactions at issue, if they're one-offs. An agreement from the buyer and its agent to provide the necessary information. This is particularly problematic in an EXW or Exworks transaction. The U.S. principal party in interest, regardless of whether you've met the requirements of 758.3 and specifically delegated responsibilities between the parties, the U.S. principal party in interest retains some responsibility on what they know or didn't know, what they had a reason to know about the transaction, how the transaction proceeded, and to audit and make sure that things are faithfully reported. For this reason, I think it's very important that that the USPPI, regardless of the relationship with the forwarder, have in place provisions that require the forwarder to report back information regarding the transaction, and that there's audit procedures in place to assure that indeed that information is reported back. So you want the date of export and the port of export, the country of ultimate destination, the destination port, the method of transportation, carrier, any licensing information, and the ITN, which is the serial number of that exportation, if you will, in the AES system when it's reported. Ideally, you want a copy of the bill of lading. That's sometimes hard in an Exworks transaction because there may be the end user may be hidden from the seller, but if the end user is hidden from the seller, there's additional compliance risks that one must deal with anyway. So I would argue that you should have a copy of the bill of lading on the export transactions also, so that things are clear. Apply the stranger danger principle. I look at it this way. Sometimes you're required to use, on an export, the U.S. principal party in interest is required to use a freight forwarder selected by the buyer that may not be known to them. And I think that there is it is reasonable for the U.S. principal party in interest to qualify that freight forwarder. I compare it to a bank who may be issuing a loan, a construction loan, and wants to qualify the contractor before the monies are issued on that loan so that they know that that contractor is authorized to receive the funds and is creditworthy. I think a similar thing works for the freight forwarder, and I would urge U.S. principal parties in interest to qualify the freight forwarders. Have freight forwarders, if they are not able to get information back from the freight forwarder in a timely manner with regard to the transaction, it would be reasonable to say, we are happy to ship this on an Exworks basis, however, we cannot work with that freight forwarder. They don't meet our qualifications, and they aren't giving us the information that we need. They're creating an additional risk for the company that isn't baked into our price for the goods. Therefore, we can't use that freight forwarder. The condition, the agreement with the foreign principal party in interest on the provision of the necessary electronic export information. So the buyer is a party to the provision that they must arrange for that information to come back to the USPPI. Require the forwarder to report any destination changes. That's very important. That's a transshipment risk. So if you think that the goods are going one place and they are being moved to another place, the USPPI would want to know that. And one could argue, you've let go of the goods. Why do you want to know that? I would say that the problem that one faces is that someone in the organization may know, there may be a record someplace, an email communication someplace that suggests that this change in destination was known Perhaps it was the selling agent or the salesperson within your organization just knew that and arranged for the transaction, saying, oh, that's not a big deal, so it's being called going to one place and it's actually going to another. It's only for logistics reasons, but in hindsight, that could be problematic. I mentioned restricting the duration of the power of attorney and other authorizations. I mentioned audit in passing, but I'll expound on that now. It has been common practice on the import side for a long time to audit entries, at least randomly audit entries. Pick a selection of entries and make sure you can trace the data and make sure that the information is faithful to the invoice and to the information in internal systems. That hasn't always been the case on the export side of the house, because exports, the reporting was less formalized. While there was a shipper's export declaration, they weren't as the penalties weren't as substantial. The penalties weren't issued as often. They weren't filed electronically. There wasn't a targeting system in place, and so for a bunch of reasons, exports weren't generally subjected to the audit procedures that have been imposed on import transactions. I would say with the change, the movement of the automated export system to ACE, the automated commercial environment, companies should consider adopting a more formalized system of auditing the export transactions to make sure that the information reported through AES accurately reports the information as understood by the company. And consider the internal document review procedures on all routed export transactions. Routed export transactions, because of the inability to control the sending of goods out of the United States and the inability to control the reporting of the electronic export information, create a higher risk for companies. And so I strongly urge that the companies consider adopting an internal document review procedure for all routed export transactions, if they have to do them. I would first caution against using routed export transactions and use a different term of sale. So we're going to deal with some common routed export transaction questions. So here's the first one. The foreign principal party in interest arranges for the transportation but allows the U.S. principal party in interest to file the electronic export information. And the question is this a routed export transaction? It's actually a trick question. Here's the definition of routed export transaction under the census regulations, the foreign trade regulations, and under the export administration regulations. So under the census regulations, you have to have both the agent facilitating the exportation of the items from the United States and the filing of the electronic export information. Notice, however, that the export administration regulations do not mention filing responsibilities. So this would be a routed export transaction under the export administration regulations, but not under the foreign trade regulations. Notice that when we talked about the foreign principal party controlled export transaction, that definition changed some of this to hopefully align these answers a little more closely. There's a question up about whether companies are currently able to access export data in ACE, and that's not the case yet. No, that's being developed by Customs right now. I would say we're probably at least 6 months out, maybe a year out, before ACE will be modified to gather export information. There's a fair amount of programming to do to get there. So the next question. Is this a routed export transaction? Here's the scenario. Our company in the U.S. sells to our sister companies in different countries. The sister companies assign the freight forwarder to handle the export and file the EEI. Would this be a routed export transaction? The fact that it's a related party transaction does not change whether this would be a routed export transaction. It's a routed export transaction because the foreign party, foreign principal party in interest is assigning the responsibilities to the freight forwarder to handle the export and to file the EEI. It would be a routed export transaction under both the Census regs and the Bureau of Industry and Security regs, because BIS regs only require the freight forwarder to facilitate the exportation, and so that the freight forwarders doing other activities wouldn't change that. Goods shipped via courier collect to the customer's account. Is this a routed export transaction? And this is another trick question, actually. And the trick here is that most forwarders refuse to most couriers, refuse to handle routed export transactions, and they won't do the reporting under a routed export transaction. So it's very rare that a courier shipment would actually be a routed export transaction. You would have to work your way around it, ideally changing the Incoterms if necessary, because the courier wouldn't do the export, file the electronic export information. It's usually in their terms and conditions. They won't handle a routed export transaction in most situations. So it's a bit of a trick question. I just threw that in for fun. A couple more examples. These have always been highlighted and have generated a lot of questions. The drop shipment. So who is the U.S. principal party in interest? Who is the foreign principal party in interest? And I'm going to throw out which value is the correct value for export reporting. So we have U.S. Company A selling goods to U.S. Company B, who's selling goods to a foreign purchaser, and U.S. Company A U.S. Company B directs U.S. Company A to ship the goods directly to the foreign purchaser. So first is, who is the U.S. principal party in interest? U.S. Company A or U.S. Company B? So we have a bunch of go back and forth. In this case, U.S. Company B is the U.S. principal party in interest. They are the party receiving the financial benefit of the export transaction. There's actually the sale between U.S. Company B to the foreign purchaser is the relevant sale for export. The sale from U.S. Company A to U.S. Company B is actually merely a domestic transaction. So who's the FPPI, the foreign principal party in interest? I think that one's pretty obvious. And then the question is, which value? Is it the value from U.S. Company A to U.S. Company B, or U.S. Company B to the foreign purchaser? And it's going to be the value of U.S. Company B to the foreign purchaser. That's the relevant transaction, and that is going to be the value for the export. Let's look at a different drop shipment scenario. So here we have U.S. Company A selling to foreign company A, but shipping to another company, foreign company B, foreign purchaser, or foreign company B. So we only have one U.S. party, so I think it's going to be obvious who is the U.S. principal party in interest. But who's the foreign principal party in interest? Is it foreign company A or the foreign purchaser? We have a bunch of people weighing in, and I would agree, most people are saying foreign company A is the foreign principal party in interest. Then what is the value to be reported? The price between company A and foreign company A, or the price between foreign company A and the foreign purchaser? The answer is going to be U.S. Company A to foreign company A. That is the foreign sales price. The problem comes in here often that the foreign company A, who's buying the goods from U.S. Company A, wants U.S. Company A to issue an invoice at its higher price, its foreign company A to foreign purchaser price, to foreign purchaser to use in the clearance of the goods when they arrive at the foreign purchaser for customs for the foreign purchaser. So that creates a problem for the company, but the reporting to Census is the company A to U.S. Company A to foreign company A price. So we're now, that's my prepared presentation. I'm going to go back, and there were some questions that I will try to address, and please feel free to chime in with any additional questions, and I'll address them now. First question I have is, do I have a list of questions for use to qualify freight forwarders? Yes, I would say please send us an email, and I have an article that I wrote a couple of years ago on that, and I'll be happy to forward the article. Next question, if we ship to a sister companies and we file the EEI, is this a routed or non-routed transaction? So I would say under the census regs, it's definitely a non-routed transaction because assuming that the person asking the question is not a freight forwarder, an agent isn't doing the filing of the EEI. The USPPI is doing the filing of an EEI. Whether it's routed or not routed under the BIS regulations would depend on who's controlling the transportation of the goods. But it would not be reported as routed in AES. Next question, for DDP with an import, does the USPPI need to give the foreign vendor's freight broker a power of attorney? I'm not sure I'm getting this question. So this is DDP, are we talking the import side? I'm assuming we're going to talk the import side of a DDP export from the U.S. Because we're referring to the USPPI. And whether the USPPI will need to give, see, the foreign vendor's freight broker, a POA, doesn't make sense if it's delivered duty paid, because if it's delivered duty paid, then the USPPI has contracted with the freight broker. It's not a foreign person's freight broker. So let's turn it the other way. It's DDP on an import. Then we don't have a USPPI per se. The question would be, does the purchaser need to give the foreign vendor's freight broker a power of attorney? And I would say no, because on a DDP on an import side, the foreign person is going to be the importer of record, and they have to give their customs broker a power of attorney. There's no determined yet on when this notice proposed rulemaking will become finalized. So the new term, the foreign principal party controlled export transaction, is not, we don't know when it's going to be in place. But the elements of 758.3 that deal with what is needed to transfer the export responsibility from the USPPI to the FPPI, I would say are good guidelines for going forward, even though they aren't in the regulations. I think it's much more a clarification of what the prior regulations stated than anything new. Are separate forms required with routed export to have a buyer take responsibility for licensing determination, as well as another form to authorize their agent to file their EEI, or can all this be included in one form? I would say that there will be two forms, because one is going to be an agreement between the buyer and the seller, where the buyer is taking on the licensing responsibility. The USPPI is still going to have to authorize the freight forwarder, the agent of the buyer, to file certain EEI information on their behalf, because they're still the USPPI and still listed in the reporting to census as such, and have to authorize the freight forwarder on their behalf to file that information. So there are always two writings. What is the reasonable duration for a power of attorney? You mentioned having a time limit on it. I would say we'd like to limit it to 2 years, which I think is reasonable. 1 year would be coming back and forth too much. And 2 years is what the law requires for a power of attorney issued by a partnership. So we've just adopted the 2-year period. So I think that's all the questions that have been posed. I'll wait a few more moments if anyone has any additional questions. And if not, I will thank you all for calling in, and feel free to contact me. My contact information is here. Feel free to contact me with any additional information you may be interested in. Well, thank you very much, and I hope everyone has a good day and a good fall.